Hello viewers, today I will be talking about natural rights. I am Dr. Surabhi Gupta, Assistant Professor in Police University, Jodhpur. Let's start. First of all, let's start with what are rights. Rights are essential conditions for good life. They help in the all-round development of people and their personality. According to Harold Lasky, rights are those conditions of social life without which no man can be his best self. So, rights are basically the prerequisites or the essential conditions without which a human being cannot realize the very purpose of his existence or cannot realize his or her full potential. So, they are actually essential conditions which are required for an individual to be his or her best self. They are actually the claims of an individual's necessary for his own existence. And this definition of Harold Lasky is very important and very popular when it comes to rights. He has very beautifully said in single line that rights are the essential or those conditions of social life without which no man can be his best self. So, it brings out the importance of rights in human society and culture, and all human society and culture have developed certain concept of rights in their own way, and some of these rights are universal in nature, whereby they are just because of the fact or virtue of the fact that an individual is born as a human being and it is required as a part of human nature. Now let's come to what are natural rights, as our topic of today is. Natural rights are something which are natural. They come from nature and not created by any artificial agency. So, as the term suggests, natural rights, that is something which is derived from the nature or which something which exists independent of the state and society, or which is actually given to us by God, which cannot whose existence or for whose enjoyment we should not be, or we are not dependent on any artificial agency or state. We need to be given, or we need to have those rights by virtue of being human being. There are certain inalienable and inherent rights derived from the basic nature of individual as a human being. Professor E. Ashirvathan believes that rights inhere, these rights, natural rights, inhere in the individual. He says they inhere in him, they are a part of him, part of his natural existence. They are as much as a part of man's nature as the color of his skin. They do not require elaborate explanation or justification for their existence. They are self-evident truths. One simply assert them dogmatically. That is, another important thing which comes is that they are not only inherent, inalienable, basic human rights, but also they are self-evident truths. That is, one need not give any justification for their protection or for their maintenance, nor one has to depend upon any institution or any agency for their realization. They are derived from the humanness of every human being. Cicero has beautifully summed up the theory of natural rights: the existence of a universal and worldwide law, which is one with reason, both in nature and human nature, and which accordingly knits together in a common social bond every being that possesses reason, whether God or man. So, it binds humanity together in a certain relationship of natural rights. Now, the question arises as to, since it is a very abstract concept, now the question arises as to what are those natural rights which human beings fight for or which they espouse for. The most common natural rights are right to life, liberty, pursuit of happiness, but there are individual variations on this among the scholars, or there is a difference of opinion among the scholars as to what constitutes natural rights. Some examples of natural rights are the right to life and the pursuit of happiness. These are rights that people have simply by virtue of being human, meaning that they are not dependent on any social status or condition. Two common natural rights are the right to life and liberty, while Thomas Jefferson advocated for the right to the pursuit of happiness. So, what is commonly accepted is right to life and liberty. John Locke has added another important right, that is right to property as a basic natural right, which I will discuss further. And Thomas Jefferson, who actually gave the American Declaration of Independence, who was the brainchild behind American Declaration of Independence, he called right to life, liberty and right to pursuit of happiness as natural rights. So, there are difference of opinion among the scholars, but you should widely believe that right to life, liberty and pursuit of happiness constitute basic natural rights. Natural rights were very popular in the 17th and 18th century political thought. That is, the theory of natural rights came during this time when we saw glorious revolution in England, which led to the overthrow of King James II. And during that time only John Locke came with his book Second Treatise on Government. The very idea of natural right is based on a political theory that every person has basic rights that the government cannot deny no matter where they live. Natural can mean being independent from society or from a theological perspective based on the obligation God has given man, such as the right to life based on the commandment, thou shalt not kill. We have read in the Bible the basic commandment which God have actually endowed every human being, that right to life is a very sacrosanct right, and no individual, no authority, no agency has the right to deprive another human being of his right to life. So, it exists according to the supporters and theorists of natural right, it exists even independent of state, and the sources might be even theological. The theory was broadly developed on two important bases, the contractual basis and the teleological basis. Now, this theory, every theory needs a ground to support its opinion or its viewpoint. So, this theory was supported by contractualists as well as those who believe in teleology. Now, when we talk about contractualist, the name which come to our mind is Hobbes, Locke and Rousseau. Now, what are the grounds of which they have given in support of their theory of natural rights? According to this theory, certain rights were enjoyed by man in the state of nature, that is before the formation of civil society itself. All these social contractualists, they believe that there existed a state of nature. Their theory actually proceeds from first of all understanding the state of nature. Their theory is advanced on the precondition that there existed a state of nature before human beings entered into a social contract to create a state. So, what is the state of nature? This is certain situation which existed before the formation of civil society itself, and they believed that in that state of nature human beings enjoyed certain kind of natural rights which was or which must be respected and protected by the state. The first name which comes to our mind when we talk about social contractualist is Hobbes. Social contract theory was introduced by Thomas Hobbes. Hobbes draws a very gloomy picture of the state of nature and deprecates natural rights as the freedom of the stronger to oppress the weaker. He therefore postulates an unconditional surrender of natural rights when civil society is formed. Natural rights for him were nothing more than the natural powers of men used to oppress other. Now, according to him, it was a very gloomy or it was a very sad state of affairs. It was complete. In the state of nature, there was complete anarchy. There was complete lawlessness. It was a rule of, it was a jungle rule where might was right. In that situation, what natural rights according to him were? that is the right to oppress and suppress the weaker. That is actually intends to mean natural powers of man to actually dominate and to inflict his upper hand over the others, over the weak. So, for Hobbes, the natural rights were just a right or just a means to oppress, or the powers to oppress the weaker. The power of the strong to oppress the weaker constituted natural rights, which for most of us we will not agree with this concept of natural right. It was actually very partial, or it was completely ungrounded. So, to complete or to actually substantiate and to find a more reasonable ground and reasonable meaning of natural rights, I will proceed to John Locke. John Locke, he was the major proponent of natural right. The most influential statement, he was also a social contractualist, and his statement on natural rights was published in his book Second Treatise on Civil Government. I told you it was the time of glorious revolution in England, when people were demanding, or were resisting the dictatorial or the totalitarian regime, and they stood against the oppression of the stronger and wanted to overthrow the government. At that time, he actually came out with his theory of natural rights. He famously claimed that all individuals have a right to life, liberty and property. No sovereign could legitimately infringe on these rights. So, he gave this very strong theory of natural rights, which is mostly accepted, widely accepted, that is, natural rights were not just what Hobbes said, the right or the power of the strong to oppress the weaker, but natural rights means the right to life, liberty and property. These were certain natural inalienable rights which must be protected by the individual in every situation, whether it was state of nature or whether it is a civil society. So, even after the formation of state, he supported that these natural rights were unaffected by the creation of state or society through social contract. So, these natural rights considered sacrosanct, which must be enjoyed by individuals in every time, in every situation, whether it is state of nature or whether it is a civil society or a sovereign government. So, these rights should be respected because they are certain rights which are derived from the virtue of being a human. For Locke, the preservation of individual rights is one of the driving reasons for entering into the social contract. Now, what Hobbes said, that people entered into social contract in order to give up this right and to give this natural right to state. But Locke said that people do not surrender these natural rights even when they enter into social contract. What one natural right they surrendered to the state was right to be judged, that is, right to punish in case anybody violates the natural right of others. So, for him, this is, even the civil society or the sovereign government is an extension or is founded on the principle of governance of these natural rights. He said, listen to this very carefully, Locke said that man surrendered only some of his natural rights, that is, the right to be the judge of his own acts, on the condition that his fundamental natural right, that is, right to life, liberty and property shall be protected by the state. That is, man in no way, in no condition has surrendered these rights, rather he has instituted the agency of the state to protect these rights by giving just one right to the state, which earlier human beings enjoyed by themselves, that is, right to self-preservation, that is, right to be judged in case anybody violates their above mentioned rights. He said that if the state failed to maintain these rights, that is, these natural rights, man had the right to overthrow government and to set up a new government in its place. Thus, it was Locke who tried to demonstrate how natural rights, that is, the rights derived from the state of nature, could form the basis of the principle of governance. That is, he believed in limited or a constitutional government whereby which will respect individual's natural right. John Locke's theory of natural rights was highly influential. For instance, his theory was important in developing the United States Declaration of Independence, which emphasized the right to life, liberty and pursuit of happiness. I already told you that Thomas Jefferson, who actually laid down this American Bill of Rights, he was highly influenced by opinion of John Locke at that time. While Jefferson, rather than adding property, he added pursuit of happiness, but right to life and liberty were followed by both these thinkers. Locke theory was preceded by natural law theory, which held that laws should govern human conduct that societies or governments did not create. So, Locke's theory was actually preceded by his concept of natural law, that is laws, natural law laws which govern human conduct that societies or governments did not create. Now, what is natural law according to Locke? Natural law according to Locke consists in the rules of morality implanted in human conscience. Locke believes that all human beings have to necessarily adhere to natural law, which obligates them to not harm each other with respect to each other's life, liberty and property. So, according to Locke, natural law is a precondition for natural rights. And what is natural law? It is actually believed that there is basic moral responsibility and consciousness in every human being which actually make him or which actually compel him not to violate others' natural right to life, liberty and property. So, this is a natural obligation. Natural law is actually natural obligation on the part of all the individuals to respect each other's natural rights. So, this was the principle of governing human relationships and enjoying individual natural rights in the state of nature under the umbrella of natural law. Natural rights consist in the perfect freedom and equality of every man, not only to preserve his property, that is his life, liberty and estate against the injuries and attempts of other man, but to be judge of and punish the breaches of natural law committed by others. So, natural law or natural rights also impose another important right or also give us another important natural right, which is very important, right to self preservation. That is, in any case if there is a breach of your natural rights, every man has this power or have this right to protect his life and liberty against the encroachment by other. So, this we also can call as right to self preservation for the sake of natural rights. When men enter into political society, they surrender their natural rights to be judges in case of breaches of law. This power is now vested in the community instead of individuals, but they still retain their natural rights to life, liberty and property. So, overall what John Locke intends to convey is that these natural right to life, liberty and property do existed even in the state of nature, will continue to exist even after the creation of civil society. The difference is that individual has surrendered the right to be judged in case of breach of natural, in case anybody violate those natural rights, to the society, to the government or to the sovereign agency. Otherwise, all the natural rights, all the basic right to life, liberty and property are retained by the individual as and then. A central argument made by Locke is that these natural rights do exist even in the state of nature. They are pre-political and in effect granted by God and held by every individual from birth. And what is the obligation imposed by natural law which existed that time? That natural law mandates that everyone respect these natural rights in each other, The only reason for which one can justifiably violate them is when somebody is threatening to violate others' natural right. That thus, if someone threatens to take away another person's life, then that person is justified in taking the offender's life to preserve his or her right to life. Otherwise, natural law demands that everybody respect each other's natural right unless and until they are violated or encroached upon by another individuals. Locke argues that natural law obligates that all respect each other natural rights. For Hobbes, right to self-preservation means one is at liberty to do anything for its sake. In contrast, Locke would argue that one's exercise of liberty should be compatible with natural law. Therefore, one is justified in pursuing their rights only to the extent that it does not violate other natural rights. So, he tries to balance individual's natural right, that it should be compatible with the same degree of natural rights so that it can be enjoyed by all individuals, and any such kind of violation is guaranteed on the ground that it is that their rights are under threat. Now, what impact natural rights had in the history of mankind or in the present system or scheme of rights which we are enjoying? The theory of natural rights played an important role in modern history. It served as a source of inspiration for the American and French Revolution. American Declaration of Independence 1776 expressed this idea as follows, which came out with American Bill of Rights. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute a new government, laying its foundation on such principles and organizing its power in such a form as to them shall seem most likely to affect their safety and happiness. That is, the rule or the basis of government is that in the first instance it protects the basic natural rights of individual, that is right to life, liberty and pursuit of happiness, and no state has the right to exist if it fails to protect these rights, and the people have the right to overthrow the government. Similarly, the French Declaration of the Rights of Man and the Citizen 1789 expressed the idea as under: men are born and remain free and equal in rights. Social distinctions can be based only upon public utility. The aim of every political association is the preservation of natural and imprescriptible rights of man. These rights are liberty, property, security and resistance to oppression. So, French Declaration of Rights of Man and Citizen have given a vague understanding of the natural rights, that is right to life, liberty, security and resistance to oppression, which should be the guiding principle for every society and for every government, and should not be and no individual should not be deprived of these rights. Now, to elaborate on each and every right, first, right to life. Right to life is synonymous with self-preservation, and Locke argues that in the state of nature, one has the right to do anything to preserve themselves within the bounds of natural law. One is thus obligated to respect other people's right to life as long as it does not come into competition with one's own right to life. So, right to life is right to self-preservation, that is right to exist, and this should not be compromised by any way, even if it demands attacking or if it demands the punishing the offender of others' natural right to life. Now, right to liberty. Right to liberty in the state of nature means that one should have the freedom to pursue their life ruled only by natural law and not by dictates of other. As the term itself says, liberty, that is, you are free to do whatever you want to do without the coercive powers of the state and government, and the state should not intervene in the exercise of individuals' free abilities and talents. Locke recognizes that when a person enters civil society, there might be additional laws enacted by the state. That is where the concept of social liberty comes into play. Locke contends that a person in civil society has liberty as long as he lives under laws enacted by institutions to which he or she has consented. That is what he calls as social liberty. So, after the state is created, he has given the same natural liberty or right to liberty, just a different nomenclature, that is social liberty, that is right to liberty exercised in the state of civil or in the condition of civil society or government. Right to property was a very important natural right which was actually uniquely presented by Locke, because Locke believed that his right to property was based on his philosophical foundation of theory of property. So, to give a philosophical foundation, he used the theory of property based on labor. His labor theory went on to become a foundational principle of classical liberal economics as well as Marxian understanding of the value of commodities. He said that if one's life and body are one's own property, then Locke contends that the result of one's labor with that life and body should be an extension, should by extension legitimately belong to that person. So, how he has supported right to property? That since right to body and right to life is one personal right, so if any person uses them through his labor and applies his life, his labor, his body to any commodity, so any property or anything which comes out of that is an individual's own entitlement, and nobody should be deprived of that, and no one can take away their basic right to property. So, he supports this right to property on a very genuine or philosophical foundation of theory of labor. So, this creates a labor theory of property, that whatever one creates with mixing of his or her labor belongs to that person. He has given an example also, that an uncultivated land might be common property of humankind, but the moment someone mixes his or her labor to cultivate it, Locke argues that the land has legitimately become the private property of that person. So, this way he has offered a justification for natural right to property. So, another theory of natural rights is based on teleological grounds. This teleological view of rights seeks to relate the rights of man with the purpose of human life. The supporters of this teleological view were Tom Paine and T.H. Green, who has supported the theory of natural rights on the ground that they serve the basic purpose of human existence, or they help an individual to realize the purpose of his existence or to realize his or her self. Tom Paine has brought out this theory of natural rights in his book Rights of Man, and he said that they derive their sanction from the natural rights pre-existing in the individual. And Thomas Green has sought to build his theory of natural rights on teleological basis, that they do not emanate from a transcendental law or from a God gift, but they are derived from the moral consciousness of an individual. Since all individuals share moral consciousness and all want to pursue certain common moral ends or objects, therefore all are entitled to enjoy some common natural rights. They cannot be divorced from an individual, because ultimately the aim of state is moral. State is a moral agency and its end is to realize or help individual in realizing the moral consciousness of an individual, for which natural rights are very essential or vital. So, Green said that the rights does not depend on recognition, because their recognition is based on the moral consciousness of the community. So, Green is not concerned with legal rights. or ideal rights. He is concerned with the moral rights which are derived from the inherent moral propensity of a man. Now, I would sum up the theory of natural rights by first of all bringing out the criticism leveled against it, which will help us to understand natural rights in full shape. Natural rights are highly criticized because of their basis, that is, they exist even without the state, as all the scholars generally believe that rights are the claims of an individual against the state. So, how can an individual have those claims or the rights without a state, because rights are the claims of an individual which are recognized by the society and protected by the state. So, no such theory of rights which believe that rights existed independent of the state is actually invalid and ungrounded. I will again repeat that the critiques of natural rights theory say that no rights can exist independent of the states, because otherwise rights will just be powers, they will not be the claims of an individual against the state, because only those claims which are recognized by the society and protected by the state are defined as rights. So, what the contemporary scholars have done is that they have actually revised the nomenclature natural rights to human rights. So, the concept of natural rights has been actually interpreted in a different manner. Most states and international organizations widely invoke the concept of human rights like United Nations instead of natural rights to determine their policy objectives or goals. Human rights are based on recognition of human dignity, which cannot be exchanged for any type of substantive benefit. And for this, when we use the concept of human rights, it finds widely support and acceptance. Another last criticism against natural right is that it is a very subjective term. It is very difficult to find, as we have already seen, what constitutes natural right. For example, long ago during Aristotle time, even slavery was considered as a natural right, and the rulers or the masters have a natural right to have leisure with the use of slaves. So, it is a very subjective concept. Every society, every scholar and every regime have evolved their own concept of natural right to justify their class oppression and to justify their establishment or their principle of rule. So, natural rights are basically, to sum up, they are the basic, inalienable, inherent human rights which are just because of virtue of being a human.